Hi, I'm Rick Merrill. You can get a hold of me at rickmerrillattorney.com. I'm an attorney in Everett. I just want to talk to you briefly a little bit about criminal offenses if you're charged with a crime. Crimes in this state are classified, whether or not it's a misdemeanor or gross misdemeanor or a felony, by their maximum penalty. And by that I mean any crime that has a maximum penalty, the most they can do to you is put you in jail for 90 days, that's a misdemeanor here. If it's a crime that the most they can do to you is put you in jail for 364 days, I know it's weird that it's not 365, but that's another long story. But so 364, sorry, that's what's called a gross misdemeanor. So any crime that you can go to jail for or prison, really, that's more than a year, that's classified as a felony. And there are three classes of felonies, A, B, C, and it kind of depends on, C is the lowest, B, A, and it goes up to your maximum penalty. If you're charged with a felony, we have determinate sentencing in the state, and we have had since 1984. It's called the Sentencing Reform Act, but that doesn't matter either. And it has a sentencing grid. Let's say you're convicted of a crime, and across the top of this grid it has your criminal history. So if you've never been convicted of a crime, your history is 0, and it goes 1, 2, 3, all the way up to however far it goes, however many offenses you've had. That's the top, that's your criminal history. Down the side, crimes are listed or classified by seriousness level. So let's say the seriousness level is 3 and you have no criminal history. They go down here and there's this grid, sentencing grid, 3 to 9 months, whatever it is. So they have that determinate sentencing. The judge has to sentence you if you are convicted on a felony case within that sentencing grid. They can't go less than 3 unless there are mitigating factors. They can't go above 9 unless there are aggravating factors. Those aggravating factors would be maybe it was a crime against a person, the victim is very feeble-minded or something like that. They could go mitigating if the person that committed the crime is feeble-minded or drug offenses or those types of things. There are a number of other things you can do with felonies. There's a drug court, there's a mental health court, those types of things. DUIs, we get a lot of calls on DUIs. That's a gross misdemeanor, so the maximum penalty is 364 days in jail. It's not a felony, it's a gross misdemeanor. We know that now. And there's a sentencing grid kind of with that too, because if you get convicted of a DUI and it's your first offense within a 7-year period of time, there's either a mandatory penalty of 1 or 2 days in jail, there's a mandatory loss of license, there's a mandatory ignition interlock if it's an alcohol offense, those types of things. If you get convicted of a second DUI or third or fourth or so on and so forth, within that 7-year period of time, your penalty is significantly enhanced mandatorily. So let's say you get a DUI conviction. I get a DUI conviction today, my blood alcohol level is at 0.10, mandatory 1 day in jail. I'm on probation. 2 years later, I get another DUI, and my blood alcohol level is the same. There's a mandatory 30 days in jail, just because it's your second offense within a 7-year period of time. And you can imagine that things get worse as you go. That's generally the only crime that has mandatory jail. The only gross misdemeanor, that has mandatory jail. There's mandatory loss of gun rights for some offenses, even misdemeanors can do that. But what happens if you're charged with a crime? Your first appearance is what's called an arraignment. The court gets you into court, tells you what you're charged with, sets future court dates. And from there, your attorney would get the police reports and try to find a way out of it for you. But that's, in a nutshell, that's kind of criminal defense. So.